Court does call the case of Lakestone Apartments versus Amanda and Tula.
Before this hearing even begins, pay close attention because this is not a routine eviction case. What looks like a simple dispute over unpaid rent quickly turns into a fascinating debate about contracts, communication, and whether one mistake can completely change the legal rights of both parties. On one side, the apartment complex claims nearly $9,000 is owed. On the other, the tenant insists she relied on official paperwork that listed a much lower rent amount. So, who should bear the consequences of that mistake? Judge Simpson is about to examine every detail without jumping to conclusions, and that is exactly what makes these hearings so compelling. Watch how he separates emotion from evidence while still recognizing the human impact behind the case. Every answer today matters, because one overlooked decision made months earlier could determine whether this tenant owes thousands of dollars or has a legitimate legal defense. Keep watching, because the facts become more complicated with every minute, and the judge's questions reveal exactly what he believes is most important.
Good morning, Your Honor.
Good morning.
Attorney Samantha Sprague-Pete, 1931, appearing on behalf of the plaintiff.
All right. Is Miss Antula here?
I don't know who she is.
Oh, well, come on up. It's your case, too. Yeah, me either. But I think that's how it works. All right. That's okay. Your name? All right. Where are we on this case?
Your Honor, there is still outstanding rent due and owing. We do show that currently there is past due rent in the amount of $8,140.70. There are late fees currently in the amount of $225. That does reflect three $75 late fees. We are aware of the court's position on that, so we do have numbers for the $75 according to the lease, as well as the $30 that the court has traditionally permitted in the past. And then we also have charges of $160 for washer and dryer fees, utilities in the amount of $239, and court costs in the amount of $327 for a total due and owing of $9,089.70 per the terms of the lease. However, given the reduction for the late fees, the total would be $8,954.70 for the requested judgment.
All right. And what is your position, ma'am?
Well, I think there was just a big miscommunication. Earlier this year in April, they had me sign a lease addendum that I provided for the court. The opposing counsel had a less rental amount. I signed all the paperwork they gave me. I gave them everything they asked for. I dropped it off at the leasing office. They were closed over the weekend, and I didn't hear back from them for 40 days. And at that point, they said, you need to sign a new lease addendum with a new rental amount. So under legal counsel from a legal aid clinic, I didn't pay anything because I didn't know what to pay. But I don't want to keep coming to court, and I just want this to be done and over with. So I would like to.
That's how I feel on a lot of things,
Yeah,
but go ahead.
I'm sorry.
No, it's okay.
I would just like to pay September's rent.
Have you figured out what the difference would be between what you're being charged now, I'll put it that way, as opposed to what it would be under this first lease?
The first lease, well, I'm not sure what exactly I should pay. Like, should I pay the lease addendum that I signed for, or the amount that they want me to pay? Because
well, I'm asking what would be the difference between the two. Have you calculated that out in your head?
Well, it would be $1,259 versus I believe $1,492 per month. I believe that's so it would be like 200 and I'm not very good at math, 240 maybe.
Say those numbers again.
1,259 versus 1,492.
You guys are supposed to do this math for me, but you don't care. No, you just don't care. That's fine. I got it.
I'm very
I have 233 a month difference.
okay.
And what is plaintiff's position on that?
Plaintiff's position is they acknowledge that during the initial recertification, as part of the recertification documents, the lease was signed by Ms. Hantula. It was never fully executed because it was the rental amount for a 1-bedroom, whereas Ms. Hantula is not in a 1-bedroom. She is in a 2-bedroom.
This is the first major turning point in the hearing. The landlord is not denying that paperwork showing a lower rental amount existed. Instead, the argument is that the document resulted from an administrative mistake and was never properly finalized. Legally, that distinction is incredibly important. Courts often look beyond signatures and ask whether both parties genuinely agreed to the same contract terms. Judge Simpson immediately focuses on that issue because determining whether there was a valid agreement comes before deciding how much money is actually owed. Notice how neither side is accusing the other of fraud. Instead, they disagree about what the paperwork legally means. Cases like this often come down to timing, communication, and actions taken after the mistake was discovered. If you were handed an official lease showing a lower monthly rent, would you assume it was legally binding, or would you question whether something was wrong? Let us know what you would have done before hearing the judge's full analysis.
When management realized their mistake, they did contact Ms. Hantula. She refused to sign the updated one, as well as refused to provide recertification documentation, which is still outstanding on her account.
So this is subsidized?
It's a low-income housing tax credit.
Got it.
So it doesn't, she doesn't receive a voucher or Section 8, but it does require annual recertification to make sure that she fits the income parameters.
Ma'am, is that part of the distinction, I guess?
Well, when I had spoken to Sabra, who is, I consider my landlord, I had asked her if a different 2-bedroom was available because on the company website, there was a 2-bedroom that was in this price range. It was 1,200 something. Can we move it? Can me and my son, Max, who's 10 years old, can we move into this 2-bedroom that's available on the website when my lease is up? And she said, no, that's not available for you to move into. So when I signed this addendum,
Which, the first one?
Yeah.
Well, the one that you signed. Go
yes,
ahead.
renewing my lease, I had assumed that since the other 2-bedroom wasn't available, then I would be getting this price instead. Like, there was nothing that made me think that this wasn't a valid, contract. Like, they gave me it to sign, I signed it, I gave them all the paperwork, my pay stubs, my child
No,
support.
I get all that. I guess what I'm trying to figure out is, at least I think what plaintiff is indicating to me is that the lease you signed was really for a 1-bedroom
Well, but
as opposed to a 2-bedroom.
but it had my apartment number and everything. Like, it had all of my information. And there was a 2-bedroom available for that price, and there still is on the website. So I thought that I was getting,
No, I hear you. I guess I'm,
like, and then they waited 40 days. Like, I didn't get any paperwork back. I didn't get any, they waited 40 days to tell me, oh, hey, you need to sign a new lease addendum. So,
well, okay. So that was gonna be my next query. You signed this agreement for this lower amount. Did you then pay rent
I did not.
at the lower amount?
No, because it was for the next month.
You have to help me with that because
This was in the beginning of April when I signed the new contract, and then the new lease was starting in May. So a month went by, and then I noticed on the resident portal when you log in that it had a different rent amount. And so it was like about 40 days later, I emailed Sabra and I said, what's up with this? And she said, oh, you need to sign new paperwork. I'm going to leave it on your door for a new rental amount. That's the amount you need to pay. So I didn't pay anything, which I wasn't sure if I was legally what to do really in that situation. I just sort of.
well, the reason I asked that question is because you're indicating to me that you sign this document and then it's 40 days later that but you didn't pay that lesser amount?
I didn't because they told me that the lesser amount.
What were you, that wasn't your move-in date, right? Was it?
That was my lease renewal date because I've
Right,
been there
that's
for a year.
Okay. So what was your rental rate prior to?
It was 1,492.
1,492. So that's what you paid prior to this April time?
Yes.
Okay, so what what makes you think it wasn't an error on their part?
It
Because
wasn't.
your
'Cause
your
they-
rent went down.
Right. Well, because they gave me a legal contract and I thought they are, competent apartment complex that was
Yeah,
a
but
legal contract to sign.
and I don't have a problem enforcing a contract. I don't have a problem doing that. But my understanding is they did not execute the contract. They did not sign it. So basically, the contract can happen in this way. If I were to determine that that's an offer, although it might be a mistake on their part, there has to be something on your part that would lead the court to believe that there would be some acceptance of that offer. Then they might just be stuck. The problem here, and that's why I was asking, one of the ways of showing that acceptance would be payment.
Oh.
Judge Simpson has now identified what may become the deciding legal issue in this entire dispute. He is explaining one of the basic principles of contract law in plain language. Even if a written offer exists, courts often examine whether the other party accepted that offer through their actions. Here, the judge keeps returning to one question. Was there any payment made at the lower rental amount? That matters because making a payment could strengthen the argument that both parties were operating under the same agreement, at least temporarily. Notice that the judge is not announcing a winner. Instead, he is carefully building the legal framework that will support whatever decision he eventually reaches. This is why experienced judges ask the same question from different angles. They are testing the consistency of each side's story before applying the law. Do you think the tenant should have paid the lower amount immediately or was waiting for clarification the safer decision? Small choices often have enormous legal consequences.
Okay, so they make this offer to you, you pay, and then I'm not saying that the court would decide that, but then you may have a binding contract. But then here's the other part. And sort of, does this offer, they're saying it was an error on their part, basically. So then the question in my mind becomes, does it make sense that that would be an error? Well, it might, because your rent was what, $14.92, and then it drops what, $233. That would seem kind of odd, wouldn't it?
Well, I guess I had just assumed, which may have been a mistake on my part, that since the other two-bedroom wasn't available to rent, that was in that price range, that I was given this amount. It was like the same price.
But they told you, according to what you're telling me, they told you at that point that
Wasn't.
that was not available.
But then why even give me a contract with that amount on it? I was so excited I thought that since that it wasn't available, that, the landlord was being nice and like giving me the same price, even though it wasn't the same two-bedroom apartment. Even though that wasn't communicated to me, I guess I just assumed that it's just a contract that they offered me.
Understood. But what I guess I'm getting at is, let's assume they were being nice. Let's assume that this was a legitimate price.
Excuse me.
There's no payment or attempt at payment.
That was a mistake.
And that's, as I see it, that's the problem. Because if somebody were to give me something, if my mortgage payment went down I'm paying that immediately, right? Because, but the thing is here, there's no payment.
I was advised not to give a payment in case something went wrong, like I was immediately evicted, that I would need that money as like something to fall on in case it was ruled against me. I was told that. Like I was given all these different possibilities of what could happen, and
Yeah, but I'm assuming that's later down the road and not immediately out of the gate. I'm talking at the point at which they give that contract to you. That was in April, and then you're coming up on May. In May, there isn't a tender payment at that lower rate. And in there, that's where I see, and then they notify you really in two ways. One, although I don't know that this is really a notification, the portal says something different, right? And then they notify you otherwise that that's not the amount.
right.
Okay. What's wrong?
I'm just feeling nervous. I'm sorry.
Okay. All right. So let me ask you this. If I were, because here's what it seems like to me, might be the decision that the court would come to in this case. Prior to this document appearing, you're paying $14.92, right? The rental rate, so you're coming up on your lease renewal, and if nothing happens on the lease renewal, typically in most cases, you're paying the same amount that you were paying before. It would just continue, which is what really is happening here. Okay.
Okay.
It's all right. Now, if I were to rule that way, the question then becomes, you're about $9,000 in the hole here, right?
A lot of money.
Okay. So I'm going to ask the hard question now, okay?
Okay.
If I were to rule for the plaintiff that you owe this amount, and that, let's say I just made up my own statute and I said you need to pay that today. Okay, shaking your head because you anticipate my question. You don't have that, right?
I do not have that much money. I'm not. I can pay rent.
Hold on a second.
Okay.
Hold on.
I don't have.
Are you in a position to move? Okay. So let me try to paint this picture in my head a little bit, okay? You don't have the money. You're not in a position to move. And I'm assuming your little one just started school. I don't know how, right? So now you have a little one in school and you're trying to figure out where you're going to go from there, right?
Mhm.
Okay. And not only are you nervous, you're scared to death right now.
I really don't want to be here. I'm sorry.
It's okay. Really, seriously, there are days I feel that way. All right, myself. All right. So now my question becomes, what would be your way of trying to get this done?
The tone of the courtroom changes dramatically here. Up until now, Judge Simpson has focused on lease language, contract formation, and payment history. Now he shifts towards something equally important, practical reality. The judge understands that even if the law favors one side, a judgment that cannot realistically be satisfied solves very little. He recognizes that the tenant has a young child, limited financial resources, and genuine fear about what happens next. At the same time, the landlord still has the legal right to pursue unpaid rent. That balancing act is one of the most challenging parts of civil court. Judges must enforce legal obligations while remaining aware that every ruling affects real families, not just paperwork. Watch carefully what happens after this conversation, because the judge chooses to pause the hearing and speak with the parties privately. That decision suggests he may be exploring whether a practical resolution is possible before issuing a ruling that could dramatically change the tenant's future.
I would like to, because it sounds like,
Hold on a second.
Okay.
Hold on a second. What I'm gonna do is, let me pass the matter briefly. I'm gonna talk to the two of you in back.
Okay.
See what we're gonna do, okay?
okay,
And let me try to get a couple of things out of the way, and then I'll have you in back, okay?
okay, thank you, Your Honor.
Well, find out who's ready. Let me try to get these two. Can you get them to the jury room, please? These two, yes. Just follow my bailiff back, man. Court does call the case of Ping Shin versus, everybody's coming up. Come on. Versus Caillou, is it Apacapong? I mess that up every time, right? You have an interpreter present. May I have the interpreter sworn?
Raise your right hand. Do you solemnly swear and affirm that you will interpret accurately, completely, and impartially using your best skill and judgment, and to translate from English into Chinese and from Chinese into English in the matter now before the court, so help you God?
I do.
All right.
Good morning.
Good morning, Madam Interpreter. All right. State your name for the record, sir.
Yes, Christina Chen.
All right. State your name.
Ping Shen.
Oh, say aye.
All right. And why are we here today?
Yeah, I just make sure the tenants when they can make payment. Because but for this year, February 9, the hearing judge 就说这个判那个法官判的是3月到8月份。每个月，今年 for this year， 今年8月份3到8月份每个月付500块钱，结果他付了3个月就没付了。
Judge had already ruled that the tenants should pay the delinquencies.
Just as the first case centered on confusion over a lease, this hearing shifts to something much more straightforward: compliance with a previous court order. Once a judge establishes a payment schedule, the expectation is that both parties will follow it unless the court officially modifies the arrangement. According to the landlord, payments were made for only 3 months before stopping entirely, immediately raising concerns about whether the prior order was violated. Notice that Judge Simpson does not immediately criticize either side. Instead, he begins gathering precise numbers before deciding what should happen next. That approach prevents assumptions from replacing evidence. Civil court is often less about dramatic arguments and more about verifying facts one step at a time. Missing payments may have a reasonable explanation, but the court still needs documentation and credible testimony before reaching a conclusion. This careful fact-finding process is exactly why experienced judges avoid rushing to judgment.
For $500 a month until August of this year. However, he only paid 3 months. And he stopped.
How much is owing?
总共是多少他欠的钱？
总共欠
$1,100.49.
Hold on a second. Go ahead. How much do you claim is owing?
总共是一共是260016块吧，现在赔了3个月，还剩1146啊是多少
3个月1500嘛，
对，
就是1116这样是吗
？OK。
Your Honor, the delinquency is 2,616, and he paid 1,500 for 3 months, up to total 1,500. So there's still a balance of 1,116.
1,116?
Yes. 1116嘛，对哈 Yes, Your Honor.
Sir, how much do you think is owed?
Excuse me, it's $1,100.49.
1,149?
他是1100
But
1551 difference. All right.
15块5毛9的差距。
Okay, go ahead.
this just all been so much and it's been going on for so long,
这
so
个已
it's
经
just
花了很长的一段时间，
like stressful.
非常的这个
Me and my family have been trying to figure out how to pay it, but my wife is an educator.
考虑
She's
过
a school teacher. She doesn't work over the summer, so she just literally went back to work
都在上班，
last week.
一直到上
I have a family of 7, me, my 4 kids, my wife, and I take care of my mother.
The financial hardship described here adds an entirely different dimension to the dispute. The defendant is not arguing that the debt never existed. Instead, he is explaining why keeping up with the court-ordered payments became increasingly difficult. Supporting 4 children, caring for an elderly parent, and depending on seasonal household income create real financial pressure. At the same time, civil courts cannot erase valid debts simply because repayment becomes difficult. Judge Simpson now has to balance compassion with accountability. He understands the family's situation, but he also has a responsibility to enforce previous court orders fairly. That balance is one of the defining characteristics of his courtroom. Here is a question for you. Should judges give struggling families additional flexibility when circumstances genuinely change, or should payment orders remain strictly enforced regardless of financial hardship? Share your perspective because reasonable people often disagree on where that balance should be drawn.
So
Okay, so let me ask you this. When do you think you can get this paid?
你什么时候可以付他？
to be honest with you, I'm not entirely sure.
我不敢确定。
I've been trying to figure out the billing process with my wife to try to get everything down since I was the only one working. We got a little behind on everything, so trying to play catch up.
Okay, let me
各方面都付款的情况。
let me ask you this. If I were, because the court has the ability to do that, sort of restructure your payment,
如果法院能够重新
how much do you think,
方式，
as you stand here right now, how much do you think you could pay per month?
See if it's $1,100.
总共是
To be completely honest with you, it couldn't be any more than $200 a month.
他说最
Or
多一个月我付
I mean,
不能
that's
超过
kind of
200块。
stretching the limit.
Yeah.
Yeah,
Hang on, hang on.
就是一个金额
So that was,
Sometimes you say too much.
yeah. So about $200.
Well, let me ask you this.
200块以
Well, if I can just get more time, can I get till?
Sir, please
希望他是讲个不停。
cut the payments to 250 per month, understanding the summer work schedule or payment schedule.
50块钱可以吗？
When could you start those payments?
October.
通过
October 1? Because you got,
15th.
well,
My wife she gets paid twice a month.
我太太
She
每个
doesn't
月
even really
收
get her
2次的
check
那个薪
until
水，
the
一个
15th.
月可以
so here's what I'm going to do. I'm going to indicate that the current balance, I'm going to take the plaintiff's number of $1,116. Defendant to pay $250 per month beginning October 15th,
付的话是10月
2025. So I'm giving him time to pay it off, realizing the work schedule and the payment.
This ruling perfectly illustrates how courts can enforce accountability without ignoring reality. Rather than demanding immediate payment of the entire balance, Judge Simpson restructures the repayment schedule based on the testimony he has just heard. He accepts the landlord's higher balance calculation, but also recognizes that forcing an impossible payment today would likely make the situation even worse. By delaying the first payment until mid-October and reducing the monthly obligation, the judge creates a realistic path toward compliance while preserving the landlord's right to recover the money owed. This is not debt forgiveness, nor is it a victory for either side. It is a practical judicial solution designed to maximize the chances that the order will actually be followed. Effective judges often focus on outcomes that people can realistically accomplish instead of issuing orders that sound strong but prove impossible to satisfy in everyday life.
But I'm taking your number, which is a higher number, as to what's it. All right? Thank you.
By the way, I prefer he can pay to the court escrow account, not pay my director.
That's how it's set up, sir.
Pardon?
That is how it's set up.
Well, that's because you guys couldn't do stuff right. So pay $250 per month, beginning October 15th to the court escrow. All right. Thank you.
Okay, thank you.
Thank you.
Okay, thank you.
Thank you, Madam Interpreter. Court does call the case of Jeff Lewis versus Jennifer Loudon.
Morning, Your Honor. Dale Barton appearing on behalf of the plaintiffs, Jeff and Julie Lewis.
All right.
Morning, sir.
And hello, how are you? Hold on.
Good.
And verification in order to seize property. Go ahead.
This is a motion to amend the request and verification order to seize property. It was originally assigned to Moore and Associates, and it's been over a year, and my client has contacted them. They haven't done anything. We'd like to have it reassigned to the Washington County Sheriff's Department Judicial Services.
What was their response when they were called?
I'd have to ask my client. He's on Zoom.
Mr. Lewis, what was their response?
Sir, when I asked them back in July, they had indicated that they had basically closed the case because they could not move forward. And then in August, I don't know the exact date, I got a bill from Moore Associates that they actually served her in August with the seizure order. It was like a year after, we'd asked for it. So they have done something in August, but they didn't do anything prior to that, going back to August of 24.
And where are they in the process right now of?
Your Honor, the process server was when I filed this motion. That's when
Say that again.
the fee that they received, the invoice from Moore for serving the papers they are serving the papers that were in the court here today for, when I filed the motion and to amend the request in order to seize. That's the only thing they've done in a year's time, was serve her with these copies of the papers that I filed in August.
Have they received notice of your motion? And the reason that I ask is because this would be going outside of typically what the court would do.
Yes, they did.
They did. I don't have a proof of service, but I have it on Jennifer Loudon.
All right,
I don't have a proof of service on Moore and Associates. Here's what I will do. And I will make sure that, well, I guess I'm trying to figure out are JF Moore and Associates aware of this motion?
to the best of my knowledge, yes.
Yes.
Well, how do we know that?
I'll have to file a proof of service. I didn't do that, Your Honor.
But it was served on them?
I'm not, yeah, I mailed it, but
I don't know what that answer was.
I mailed it, so first class mail, and I will indicate that in my proof of service.
Well, the proof of service, we will also, and I guess in this instance, I could certainly contact them, or could just issue it, but I don't want to get into a process where people are picking their process servers this way. So what I will do is I'll need the proof of service, make sure that a copy gets to Ms. Weidling. And then I will also have my staff contact them to make sure, and if nothing's been done, then I'll sign your order.
All right, thank you, Your Honor.
Although this dispute may seem less emotional than the earlier hearings, it highlights an equally important principle of civil procedure. Fairness requires notice. The plaintiff wants authority to change the process server responsible for enforcing a seizure order, but Judge Simpson refuses to shortcut the process simply for the sake of convenience. Before granting the request, he wants proof that the affected party received proper notice and an opportunity to respond. That insistence protects the integrity of the legal system by ensuring decisions are made only after everyone has been given a fair chance to participate. It also prevents future challenges claiming that procedural rights were ignored. Cases are not won solely because one side believes it is correct. They are won by following both the substantive law and the required legal procedures. That careful attention to process often determines whether a ruling survives later scrutiny.
Thank you, Your Honor.
Well, he's got to know about the motion and I want to know what the status is on it.
Okay.
All right. Thank you.
Thank you, sir.
R&J Group Holdings versus Azar Sajaji Stanfield.
Morning, Your Honor. Anthony Mamina appearing on behalf of plaintiff R&J Group Holdings.
Really?
Yes.
All right. What are we doing?
Hopefully, Your Honor, we're denying her motion based upon the reasoning given in my response in opposition to defendant's emergency motion to compel plaintiff to return security deposit and expenses.
Her motion is denied on its merits.
Thank you, Your Honor.
All right.
Question to the court.
Oh, boy.
Good to see you, by the way, again.
Good.
Hopefully, we have to stop meeting like this.
Yeah.
Will you be providing a denial of the motion on her order, or should I submit one?
Submit one, please.
Thank you, Your Honor.
All righty.
This exchange provides a behind-the-scenes look at how courtroom decisions become enforceable documents. Even after a judge announces a ruling, someone must prepare the written order reflecting exactly what the court decided. That written order becomes the official record relied upon by the parties going forward. Judge Simpson's instruction to submit the order is routine, but it is also essential. A verbal ruling alone is often not enough for future enforcement or appellate review. Notice how the attorneys immediately discuss timing and electronic submission rather than revisiting the merits of the dispute. That professionalism keeps the process moving efficiently. Court proceedings involve much more than dramatic testimony. Administrative precision is equally important because an inaccurate order can create confusion or even additional litigation. Every word placed into the final written order matters, which is why lawyers take this step so seriously before leaving the courtroom.
Is there any chance?
You could do it today, so I can sign it. We don't even have to do it. Okay.
Okay, is it electronic or do I need to get one? Are we electronic?
If you get it and send it to Ms. Weidling,
Okay.
it'll get signed.
I believe I have plenty of examples of your email address. Thank
All
you,
right.
Judge. Have a good day.
Thank you.
Today's hearings demonstrated that civil court is rarely about dramatic courtroom speeches alone. Instead, success often depends on documentation, credibility, timing, and whether each party fulfilled their legal responsibilities. In the lease dispute, Judge Simpson carefully examined contract formation, acceptance, and the consequences of an apparent paperwork mistake before exploring whether a practical resolution could be reached. In the payment enforcement matter, he acknowledged genuine financial hardship while still requiring accountability through a structured repayment plan. Finally, the procedural hearings reminded everyone that fairness requires proper notice, accurate paperwork, and adherence to established legal process before the court exercises its authority. Every case reinforced the same lesson. Facts matter, but procedure matters just as much. The strongest legal position is built on both evidence and compliance with the rules. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.